Hello friends, in the series on the income tax cases, today we will discuss the case of K. CHANDRASHEKAR Prakash versus Assistant Commissioner of Income Tax. This case has been reported in 455 ITR at page number 751. The matter has been decided by Karnataka High Court and the date of the judgment is 10th October 2022. This case is regarding depreciation, for which section 32 is there, and some business expenditure which are allowable if they are done for exclusively and completely for the purpose of the business, and for that section is 37. In this case, and from the reading of this case, it appears that there are cases when the assessment orders are passed, assessing officer make the addition only just for the purpose of making the addition. They just want to demonstrate that they have passed the order. They make the additions without any basis, without following the due procedure of law, without keeping in mind the provisions of the law. They just make the addition because they have to do the additions. But the cost of making the additions has to be borne by the assessee in the form of heavy litigation cost and the time involved in litigation. This is the perfect example how bluntly the assessment orders are passed. In this case, the assessee purchased the software and this software was not updated by the vendor who supplied this software. Assessee made several requests to the vendor that please update it, but the vendor was asking for the payment. So the assessee simply wrote a letter to the vendor of the software that your payment will be released on the condition that you will update the software. When the assessment was going on, the assessing officer came to know about this communication, and on the basis of this communication that the payment of software will be released only when the vendor updates the software, the assessing officer disallowed the depreciation. The simple rule for providing the depreciation is that if the assessee is the owner of the asset and is using the asset for the purpose of the business, then the depreciation should be allowed. So this is not a criteria for denying the depreciation on the asset, because the date on which the asset is purchased, the assessee is the owner of that asset. The payment is not relevant because the payment does not bar the assessee from claiming the depreciation. So when this matter came to the Honorable Karnataka High Court, the court allowed the depreciation to the assessee. And the second matter before the court was that when the assessment order was passed, the assessee has incurred some development expenditure. The AO made the query from the assessee for giving the business expediency for incurring this expenditure. Assessee explained, but simply by making the allegation that this expenditure is not done as per the business expediency, the assessing officer disallowed this expenditure. When this matter was before the Karnataka High Court, the Karnataka High Court said that it is not the prerogative of the assessing officer to decide whether any expenditure is necessary for the business or not. Only the assessing officer has to see that whether this expenditure is done for the purpose of business or not, and whether there are sufficient evidence for incurring this expenditure. So if the voucher was there, if the bill was there, the assessee is entitled to claim that expenditure as revenue expenditure in its computation of income. The court also said that the assessing officer cannot sit into the armchair of the assessee and decide whether this expense is necessary for the business, whether this expense was required for the business or not. It is the point of the assessee, and he has to decide whether this expenditure was required for the purpose of business. So in this case, the Karnataka High Court favored the assessee on both the points, on the point of the depreciation also and on the point of the business development expenditure also. At the end of this video, once again I am repeating the name of the case. The name of the case is K. Chandrashekar Prakash versus Assistant Commissioner of Income Tax, and this case has been reported in 455 ITR at page number 751. The matter has been decided by Karnataka High Court and the date of the judgment is 10th October 2022. Thank you, friends.